judges.
Hello, Arizona. Good afternoon. My name is Caitlin Johnston. I am an attorney in New York City. And when I was growing up in Indiana in high school, I was a We the People participant. So I kind of know what it's like to be on your side of the table, though I never made it to nationals. So you've already bested me, and I definitely didn't do it on Zoom. So thank you for all the preparation. Congratulations on being here, and I am looking forward to our discussion.
Hi, I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And congratulations on making the nationals. And I look forward to hearing your presentation as well.
And I am Edward Volpe. I'm an attorney in Denver, Colorado. I too am looking forward to your comments and realizing how hard you've worked for 2 semesters to get to the national finals. Congratulations on your success so far.
Would you please introduce yourselves and your teacher?
Hi, my name is Shrika Kantala.
Hi, I'm Manvi Harde.
I'm Michael Chen, and our coach is Brianna Willits, and thank you all for being here today.
Very good. All right, let's get started. You know you're doing question 1, so I'm going to read it all the way through, and when I stop reading, you can begin. That'll start your time. In case I forget to ask you for the follow-ups, please remember to put your notes away. Okay? All right. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
Implied rights are rights inferred from other provisions, but are not themselves enumerated in the Constitution. The 9th Amendment protects the people's implied rights from federal encroachment. One of these rights is education, which grants freedom while furthering the common good, as individuals can make informed decisions about representation and government.
I agree with the ruling in Wisconsin v. Yoder because it recognizes the right to raise one's family, an implied personal right. Furthermore, while states regulate education due to their role in federalism under the 10th Amendment, they cannot interfere with the freedom of religion, as the First Amendment has been incorporated to the states under the 14th Amendment's incorporation doctrine, giving it precedence over education.
I disagree, as the 3-pronged Lemon test establishes the Wisconsin compulsory attendance law as constitutional. This statute did not violate the Establishment Clause, as its original legislative purpose was secular in establishing public education under the Northwest Ordinance. It only applies to attendance and is therefore not religious, and it also does not promote excessive government entanglement with religion. Thus, the Wisconsin requirement for education up to age 16 was constitutional.
The right to education is not a fundamental right in the Constitution, a position the Supreme Court has held in cases such as San Antonio Independent School District v. Rodriguez. However, since states regulate education, many states mention education in their constitutions, or as Wisconsin, in their legislation.
Article 9, Section 1 of the California Constitution states that a general diffusion of knowledge and intelligence is essential to the people's individual liberties. California named education a fundamental right in their Supreme Court case, Serrano v. Priest in 1976, after which many states followed suit, with 12 state Supreme Courts doing so in the 1990s alone.
Conversely, Article 11, Section 6 of the Arizona Constitution states that Arizona shall provide school-age pupils a free school for at least half of every year. However, in their 1997 case, Hull v. Albrecht, the Arizona Supreme Court, like the federal Supreme Court, held that the Constitution applies only to the state's obligation to fund a public school system, but does not establish the right to education.
Originally, the Supreme Court held that an individual's religious rights took precedence over other legal rights. In 1958, the Supreme Court ruled in Sherbert v. Verner that the Free Exercise Clause prohibits the government from setting unemployment benefit requirements conflicting with key religious principles, establishing the Sherbert test that laws must be narrowly tailored and demonstrate a compelling interest of the government.
However, the court reversed its position in the 1990 case Oregon Department of HR v. Smith, ruling that religious beliefs do not allow people to violate otherwise valid laws, as it creates a slippery slope argument for other legislation such as taxes. The Supreme Court is currently revisiting this position in Fulton v. City of Philadelphia after the city banned Catholic social services from placing children for adoption since they oppose same-sex marriages.
Additionally, courts emphasize some religions more than others. The framers recognized that religion shall not permit unhallowed perversion by a civil magistrate, as it infringes on individual equality. However, the Supreme Court upheld in Dunn v. Wright in 2019 that a Muslim death row inmate could be executed with the Christian chaplain instead of the requested imam under Alabama's execution protocol, demonstrating the prioritization of only certain religious beliefs.
The privilege to education, while not explicitly in the Constitution, is enjoyed by the people of the U.S., often through their states. However, education often conflicts with other rights, such as the freedom of religion, a dynamic that the people in courts have carefully balanced throughout American history.
Great. Please put your notes away. I would love to hear more about the Muslim death row inmate case that you cited from anyone on the panel. But how should we analyze laws that have an impact on religious beliefs? And let's maybe use that one as an example for fun. Walk me through the analysis there.
Yeah, so if we look at this case, Dunn v. Ray in 2019, in Alabama, there was a death row inmate, Dunn, who requested that he have imam as he was being executed. And Dunn v. Ray, this case evidently reached the Supreme Court because it was so important. But he was ultimately denied that, since Alabama statutes and execution protocol allowed for a Christian chaplain to be there at all executions. And because of this, I believe strict scrutiny should be used for cases such as this, because that deals with the most important fundamental rights, such as the freedom of religion. And under the First Amendment and the Free Exercise Clause, we believe that the freedom of religion would have allowed Dunn to have an imam for his execution.
Furthermore, in the case of the American Legion v. American Humanist Association in 2019, as applying the presumption that we mentioned in our paper, rather than Lemon test, the court found that the cross that they had put up to memorialize veterans did not violate the Establishment Clause, because of the historical importance of a cross was beyond its admittedly Christian symbolism. Therefore, the court established through this case that a symbol like the cross is not, and it's constitutional, as it does not impair one's religious practices, and it has a more secular meaning.
In your presentation, it appeared that one of you agreed with the Yoder decision and one disagreed with the Yoder decision, which is fine. What I'm looking for is whether you think that the Yoder case should have addressed the child's beliefs and the child's needs.
Yeah, I believe that instead of focusing so much on the parents' needs and the parents' beliefs, I believe that the Yoder case should have focused on the children's individual rights. As in being in a public education system, the main focus of schools is to represent the rights of the children and to make sure that children are getting the deserved education that they need. And we can see in a Supreme Court case, Arizona Christian School Tuition Organization v. Win, the parents, taxpayers or parents ideally said that the school, the Arizona Christian School, was not using their taxpayer money for field trips and such, and they did not believe that the students were benefiting from this. However, the school held its ground, said that they do value the importance of the children's education, the children's right, and we can see that the parents, as seen in Wisconsin v. Yoder, the parents' view on how schools should run their systems was not taken into account into the Supreme Court case.
I would like to disagree with this viewpoint. While this is very valid, children are often not able to make informed decisions about their lives and their livelihoods. And this is why we see that we have a minimum voting age and why children and infants cannot vote. You have to be 18 years old to vote to properly understand government and represent yourself. And Wisconsin v. Yoder, this is just one case, but we also see that in the case Pierce v. Society of Sisters, the right to educate children according to parental wishes was further affirmed as an implied right for the family. So children should not be able to choose, even though they are American citizens and American people. They do not yet have the sovereignty over their own lives to choose that.
In contrast, I believe that the most important thing that should be assessed is the common good of the majority. And through this and what's stated by Madison in Federalist 42 is that the government should have considerable power for it to be a strong government that protects the majority and the entire population. Therefore, the common good should be assessed in cases such as religion education in addition to also assessing the parents and the students.
You mentioned your state constitution, and it requires that there be funding for education. May a state or a school district use tax revenues for the support of both public schools and religious schools?
Yes. While in 1983, the U.S. Court of Appeals for the Fourth Circuit held that the state of North Carolina could compel a family to send their children to a public school rather than a private school or a religious school, in 2019, the Supreme Court ruled in Espinoza v. Montana Department of Revenue that the state could not ban funding or distribution of benefits for schools based on a religious discrimination point. That is that even though the religious schools may not be the schools that the taxpayers want to be paying for, the taxpayers do not have that right, and the state must not discriminate against religious schools.
Another example in which we can see this is Meek v. Pittenger, where there was the Supreme Court challenged the Establishment Clause, challenged Pennsylvania's laws that said that state public schools that were funded by tax revenues could supply resources and information to non-public schools or religious schools. And the Supreme Court stated that this goes against the Establishment Clause in that way.
You said that children generally can't make informed decisions until they're 18. What about a religious sect that marries off their young girls and has them married and having children before they reach 18? Would the government have the right to intervene there? How do you balance parents' rights and children's rights in that situation?
I think it's important here to consider we go back to the First Amendment, the Free Exercise Clause. So yes, each individual does have the right to their own religious beliefs, speech, petition, etc. And because of this, I believe that the children in this case would be able to argue against being married early legally, because even though we did argue that children cannot make their own decisions about school, that was argued for the common good. But for personal issues, I do believe that the children should retain their rights.
Perfect, right at time. Thank you very much. You guys can take a deep breath, sigh of relief. Congratulations, you're done. Wow. That was a lot. We covered a lot in a very short amount of time. I really liked the way you structured your prepared remarks. I love coming out the gate with a disagreement, but one that actually makes sense and is supported. And I loved the Dunn v. Ray case at the end. I'm personally not familiar with it, but what a way to hit that topic in a very kind of emotional way. Like, what's more meaningful than leaving this earth the way your religion, tells you that you should, right? So I am glad not everyone can just put something in their prepared remarks and then respond to it when it gets called up in follow up. And you were ready, as I think you were with pretty much every case you brought into the follow ups, new or referencing back to your prepared remarks. You did an excellent job of knowing the site, which is fine, but the bigger issue is being able to talk through the holding and the court's rationale and how it ties into your broader point. I think each of you took a turn doing that, and you really were very persuasive on that point. I pushed you with a little bit of an oddball question there at the end. I liked your creative answer, Michael. I think when there are issues of health and safety, there are some different rules that might apply, and you're not always going to get the religious objection trumping government intervention. But I liked where you went with it. I really enjoyed talking with all of you. Great job.
I would agree, very impressive. I really appreciated hearing from you and enjoyed the conversation. I did hear there was one person who indicated that they agreed with the decision, one who disagreed. We didn't hear from the third person, the tiebreaker, as to which way she would go in regards to that, but she's remaining silent. But there were, this is the 11th hearing we've had today on this question, and there were a number of new cases that were put forward by this group that we hadn't heard about earlier today. Mr. Volpe is going to go next. He's our constitutional expert. He'll tell you if you were right or wrong on a number of those cases, or whether he's even heard of them or not. But it was very, very impressive. And I really appreciated what you've done. You were very thorough. You listened to the questions that we asked and you answered them succinctly. That I wasn't sure, because I knew what question Caitlin was going to ask you at the very end there, and I saw the 1 minute sign come up, and she got her question in pretty quickly. And Michael, you got your answer in succinctly and quickly as well. So that was very well done by all of you, and congratulations.
I was very impressed by your command of a wealth of cases that have come down from the Supreme Court. This has been a highly litigated area with regard to education and personal rights. Certainly the court has come down on both sides with respect to different decisions, but with regard to whether or not it is a declared right in the Constitution, you are correct in referring to San Antonio School District versus Rodriguez. I thought that was very interesting. And then it gets around to personal relationships. You talk about Sherbert v. Werner, in which an employer could not fire an employee for refusing to work on Saturdays. And I thought that was very, very interesting, particularly because it was a small operation. And we've seen that religious rights can be protected in small operations. For example, Burwell versus Hobby Lobby, a small operation employer didn't have to offer contraception coverage in the health plan. Then you went on to talk about and correctly describe the Lemon v. Kurtzman three-pronged test, which I thought was very good. You did a good job of that. It was slightly adjusted to a two-pronged test in Agostini versus Felton, but nonetheless, it still has the same impact. One, is it an improper imposition upon religious beliefs? And two, is it founded upon a legitimate legislative interest in public good? And I thought you had demonstrated an understanding on that. You came up with Smith versus Employment Division. You should be aware that a subsequent case allowed Native Americans to use peyote. And that, of course, is Gonzalez versus O Centro. even though it was a prohibited substances in both the state and federal law. I thought you made a very interesting point about children making their own decisions, because you pointed out that we don't allow them to vote until they're 18. There certainly is a move afoot to give the vote to 16-year-olds, and we'll see how that works out. The 18-year-old vote is relatively recent. It didn't happen until the 26th Amendment. And I really enjoyed your reference to the Dunn case with respect to whether or not you have the right to have a minister of your own faith present during an execution. And I think if that were ever to come back to the court, they might rule the other way, saying you are entitled to a person of your own faith at the time you were being executed. And with regard to the California Constitution, you came up with Serrano v. Priest. I thought that was excellent. And by and large, I am just very impressed with your understanding with the idea that this is not an express right in the Constitution, but is perhaps implied by things like the 9th and 10th Amendment. Certainly the 9th said the first 8 don't list all of the rights we enjoy. And the First Amendment, of course, talks about both freedom of religion and a refusal to establish religion. And so of the 6 rights declared in the First Amendment, 2 of those have to do with religion. And I think that had some basis in what the colonies had experienced under the colonial rule of the British government. Because at the time, if you were a minister and preaching in a religion that was not the Anglican religion, if you were Baptist or any of the other Jewish or Presbyterian, you could be subject to corporal punishment. You could be whipped, and you could be sent to prison simply for preaching in your own church. And so when the founders put together the Constitution and began examining the role of education and the role of religion, keep in mind that Thomas Jefferson drafted the Virginia Act for Establishing Religious Freedom in 1786. And so it was fresh on their minds. And the idea that perhaps it is implied rather than stated is probably a valid point for you to make. I enjoyed your presentation. I enjoyed your breadth of knowledge. Thank you for your hard work this semester, and good luck in this competition.
Thank you so much.
Thank you, judges.
Thank you,
Thank
judges.
you.
Okay, that concludes this hearing. So we're going to give you guys a round of applause for our job well done. I'm going to go ahead